Hello, everyone. I'm Adrian Garcia. I'm a reporter with Board IQ and Ignites at the Financial Times. On behalf of SABEW, welcome. We have a great panel on the line today, and they're ready to talk about reporting on bankruptcies and debt. Claire Boston will moderate today's discussion. Claire is a team leader at Bloomberg News, where she oversees distressed debt and bankruptcy coverage for North America. Joining us as panelists today are Maria Chechian. Maria has been covering corporate and municipal bankruptcies for 9 years and is currently doing so for Reuters. Also here is Tom Hells. Tom is also a journalist at Reuters, where he covers legal issues. He has spent 8 years helping lead the company's U.S. bankruptcy reporting. And rounding out the panel is Alex Saidi. Alex has covered distressed debt, bankruptcy, and leveraged finance for several major news outlets. He is currently a reporter with the Wall Street Journal on its pro-bankruptcy team. Before we jump in, one quick point of business for our listeners. If you have a question for the panel, please use the chat function on Zoom, and they will get to it throughout the call. And with that, I'll hand things over to Claire and the panel. Claire?
Hey guys, thank you so much for joining us all today. Just to kick us off, I will let everyone introduce themselves in a little bit more depth and give their pitch for sort of why this is an important coverage area. Let's start with Tom.
Hi, I'm Tom Halls. I've been covering, I started covering bankruptcy about 12 years ago with Reuters. I worked with Reuters for about 20 years. And I started covering bankruptcy in 2009 with the financial crisis. I'm based ideally out of Wilmington, Delaware. I didn't know anything about bankruptcy or even the court system when I started doing it. And for me, it's been a great experience, a great way to learn about not just the court system, but so many aspects of the law come together in bankruptcy. You get a lot of mergers and acquisition law. You get a lot of corporate governance. And as we're seeing in recent years, you get a lot of mass tort stuff that winds up in bankruptcy. So it's a pretty interesting part of law that doesn't really get a whole lot of attention. And I think there's an awful lot of interesting stories. There's tons of information that come and get disclosed in the bankruptcy courts. And it can be just a great opportunity for people that are familiar with the system, but it does take a lot of work to get yourself familiar with the system.
Great, thanks, Tom. Maria?
Hi, I'm Maria Chechian. I've been covering bankruptcy for 9 years, for the past year and a half with Reuters, and for 6 years before that at a financial trade publication called Debtwire, and for a few years before that at Law 360. I basically started covering bankruptcy because no one else really wanted to at Law 360. It can be intimidating because it's so different from other areas of law. And it kind of has its own language. But once you get a sense of it, it can be really great and you can find really interesting stories. I think one of the most important things to keep in mind about bankruptcy is that I think to a lot of people, it just means the company's shutting down, but that's not the case at all. In fact, for most of the companies that we cover, it's their effort to revamp themselves and to reorganize and to come out the other end a better company. And there are just so many developments along the way that you wouldn't otherwise know about unless you're digging through documents or calling people or listening into hearings that are really interesting that you can find good stories from. It's also good to just know about the bankruptcy process itself. If you're writing for, obviously we're writing a lot for investors and lawyers, but if you're writing for a broader legal audience, it's so much better to have an idea of what goes on behind the scenes in the background and what it all means when you're trying to explain, what's going on with JCPenney or Purdue Pharma for a general audience. I think that's about it. The bottom line is that bankruptcy is used by companies to reboot themselves, and it's a fascinating process once you get into it.
Thanks, Maria. And Alex?
Hi, my name is Alex Saidi. I'm a reporter with the Wall Street Journal. I've been a financial journalist for a little over 6 years now, and for the last 4, I've been focused on leveraged finance and distressed debt. I came into bankruptcy more from a financial reporting angle. specifically looking into credit funds and other large-scale lenders that provided money to companies that ended up filing for bankruptcy. So as a part of this journey, I've learned a lot about the legal system, like a lot of folks have said prior to me, and I think it's from a say like an economic point of view, bankruptcy is very important and interesting because no one ever intends to file for bankruptcy, really. There are such things as prepackaged and prearranged bankruptcies, but it's typically because something has either happened inside of the company or, as COVID-19 showed, to the entire world that was not foreseen and created a financial impact that was not sustainable for companies to go through with the existing debts that they had carried before those events. So I really like it as a area to write about because it always typically reveals something interesting that's going on in the world and with companies that are big stakeholders in whatever communities they serve. So that's my approach.
Thanks. And so Alex, I think we'll start with you because we do want to talk a bit about not just bankruptcy, but kind of what happens before a company takes that step and what interesting stories there are to cover along the way. So can you talk a little bit about how to tell when a company is becoming distressed and a little bit about what kind of stories can be good to focus on during that period?
Sure. So I think to keep things simple, a good way to tell if a publicly traded company or publicly listed company is going through distress is to look at their SEC filings. Any company that has a publicly traded stock has requirements from the SEC to not just post quarterly and annual earnings on a regulated basis to the public, but also to disclose if there are material events that are occurring to their businesses that could reflect a serious downturn for them. So if you're starting to write about or hear about a company that you cover, maybe in your communities that might be experiencing some like material adverse effect to the business, I'd encourage you to hop on EDGAR. It's an acronym, EDGAR. It's a public electronic filing repository for SEC filings. So, a great place to start is the 10Q, most recent 10Q. You'll see there both the kind of financials listed. So how much cash do they have on their balance sheet versus, 3 months ago or a year ago? How much are they earning in revenue versus 3 months ago or a year ago? And if you can start to see that the company is running out of cash, they might not have access to other forms of borrowings from banks or third-party lenders, you can start to put a picture together for what's driving this decline and is it salvageable or not? Is the company maybe able to cut costs and increase their total profits, or do they have a lot of high fixed costs that they're not able to change and they're losing revenue and burning cash at the same time? So the SEC filings can be really obtuse, I'll admit, and a little intimidating if you're not familiar with a lot of the terminology, but one area you can also look for more color is in a section in most quarterly earnings reports, which is colloquially called the MD&A, Management Discussion and Analysis of Results, where that will be a little bit more of a everyday English explanation from management to kind of what's going on in the business. So that's a great area to start looking, and you can get so much information out of SEC filings. I do it every day. Just did it 2 hours ago on a story about Hertz that I wrote. But another place you can also look are credit rating agencies. Credit rating agencies.
I'm just going to interrupt here and see if we can get the credit rating slide up.
Right. We can also pull up the capital structure too, if we want to.
Yeah, we'll get this slide. Credit rating agencies are great. They include information on private companies too, which SEC filings do not.
Mhm.
And so when we're talking about companies in distress, we tend to be looking at kind of that junk section. So there's S&P, Moody's, and Fitch. All three are just different raters. And there's a scale from AAA, the best stuff in the world, all the way down to C or D, which is stuff that is actively in default. Alex, I'll kick it back to you to kind of talk a little bit about, what clues we can get from those ratings reports
Yeah.
and those numbers.
Yeah, and I
Letters,
also,
rather.
to highlight to the point you raised, everything I had said prior to this was about public companies. Obviously, there are plenty of private companies that are worth writing about and are very large. And it can be daunting as a reporter to try and find information about them when there's no public SEC record of how their financials are doing. So credit rating agencies can be a really good source of information because they will disclose information about revenues or liquidity, earnings, customers that you might not see otherwise. And yeah, as Claire mentioned, there's a scale, there's investment grade, and that's everything that's above the red line. And then there's non-investment grade or high yield or bonds, and a lot of clever marketing to find a term for what's below the red line. So, there are a lot of companies that have a lot of debt, but aren't necessarily going to file for bankruptcy that are in that top bit just below the red. So if you're looking at the S&P ratings, that would be the double Bs, even to the single Bs. Once you trip into the C category, that typically means that there is a very substantial financial risk coming to the company. That means that they're likely going to need to enter into a court process, such as filing for bankruptcy, or pursue an out-of-court solution to maybe reduce their debt load and come up with a deal with their lenders to try and compensate them through various means for wiping out some of that debt. So if you're ever seeing anything where a company you're interested in or covering has credit ratings with C's, that's a sign of extreme financial distress. There are plenty of companies with a lot of debt loads in the single B range that are kind of on the borderline, I would say. But when you go below triple C for a lot of reasons, it means that company is facing some severe difficulties.
Yeah, I think that's a good, kind of basic overview of just some hints that something's on afoot. So Alex, I want to discuss in a little more detail something you said about sort of options that a company might have when they're in big financial trouble, and when they go to court and when they try to solve things out of court. So I'd like to kick it to Maria. Can you talk a little bit about, what happens when a company files for bankruptcy? What types of bankruptcy they might pursue, and options that might not be bankruptcy.
Sure. So if a company is looking at into bankruptcy, it has a few options. Obviously, the most popular one is Chapter 11. That's generally what a company will use if it wants to reorganize or conduct a sale through the bankruptcy process. It can choose out-of-court options as well, meaning it doesn't formally file for bankruptcy, but the big benefit of actually filing for bankruptcy is that it pauses all litigation against the company, and creditors can't come knocking on your door and say, pay me now. It's called the automatic stay. That allows a company to just file for bankruptcy and gives it some breathing room to figure out what it's going to do. And so Chapter 11 is a popular one, but then there are options within Chapter 11. You might go into bankruptcy with, I think someone already mentioned this, what's called a prepackaged plan, which means you have a plan to fix your debt problems and to reboot the company. And you already have creditors who have signed off on it. You have all the votes you need. All you need now is the judge to sign off on it, basically. So that's usually a very quick, easy way. Well, not easy. All the hard work happens before the bankruptcy, but that's a quicker way to go through bankruptcy. Other options are to have some sort of an outline of a plan that you've struck a deal with some lenders, but maybe not with every single creditor group that you need. That's usually called a restructuring support agreement or something. In that case, you've got the outline of a plan basically, but you still need to work to get support from other groups of creditors, as well as the judge's sign off. And then if you don't have any of that, if a company is going into bankruptcy with no real plan whatsoever, we call that a free fall. And that's just kind of anybody's game. It's important to pay attention to like early hearings in those types of bankruptcies to get a sense of what could happen. That's also a good opportunity, I think, if you're looking for scoops to figure out what's going on behind the scenes that's not happening publicly.
Yeah, and I would just
yeah.
add quickly here, we're talking a lot about Chapter 11, and that's one that you hear thrown around a lot because that's most cases, and that means that the company is going to try to come out of this alive on the other side. There's also Chapter 7, which is better known as liquidation cases. You'll see small businesses do this sometimes, but if you're writing about a larger company, typically they're going to try to reorganize and come out on the other side.
Right. And every once in a while, you'll see a liquidation happen through a Chapter 11 too, but generally it's used to save itself through bankruptcy.
I think that's a good, I think that's a good place to kind of jump into discussing, maybe a company is filed for bankruptcy, it's on your beat, and you're looking for more information about what's going on. We can kick it over to Tom, I think, to talk a little bit about where to find these documents and maybe just kind of how to report out this. We can go to the slide that says case filed on it and talk a little bit about the PACER system. Tom, do you want to kick us off?
Yeah, so the PACER system is I forget what it stands for, but it's the federal court system where you can access basically any filing in any court in the country. It's kind of hard to use. It's not cheap. I think it's hard to use. It's not cheap. The page that Claire just pulled up, or whoever just pulled up, is from the 2018 bankruptcy filing by Claire's. That's the they sell the accessories, jewelries, and accessories in the malls. And this is pretty typical of what you often see with the filing. You'll see a whole bunch of all the various entities within the Claire's corporate system will all file for bankruptcy. And the reason is pretty simple. They don't want to get sued, anywhere in their corporate system. Basically, they don't want any of their holding, anything within their holding companies to be sued. So everything files for bankruptcy is pretty typical. It can be a little hard sometimes to figure out which is the case you want to follow. Usually it's the first case filed, but not so in that list of cases, it'll usually be the first one filed, but not always. But what most companies, if not every company of any size, does is they hire something called a claims agent. And
we can go to the next slide for this.
Yeah, you have a slide for that. And this makes life incredibly simple for covering corporate bankruptcies. The claims agent does what is too cumbersome for the court system to do, and that's that it organizes all the documents, puts them online, makes them all free and very easy to search in ways that the PACER system just can't. Generally, I almost never use the PACER system. I always prefer to use the claims agent system. Most of the larger cases seem to be handled by this group called Prime Clerk. And what you see on the screen there is pretty typical of how it looks when you go to the landing page. They have case information, dockets, claims, whatnot, and so on. The main thing you're probably going to end up wanting to look for if you're trying to monitor the case would be the docket. And a lot of them also, a lot of these claims agents also allow you to sign up to get email alerts when there's new filings. Not always sure you want to do that with a large corporate case because you can get absolutely overwhelmed pretty quickly, but it allows you to kind of stay on top of the case as it progresses. The first day, what you're usually going to see is you're going to see a petition. Did you have a slide for a petition?
We do. Yep.
Petition, this one runs 30 pages. That's pretty typical, or they're often a little shorter than that. Basically, it'll just give some very basic information, the name of the company, its website, the amount of its debt in various categories, like from 1 to 10 billion, more than 10 billion, 500 million to $1 billion.
Can we go to the next slide? It shows an example of the debt.
Yeah, there you go.
usually the first place, if any of us are looking at these filings, we'll look at the company
Exactly.
name and then we'll scroll down to the debt size and the assets.
It'll also list assets. The assets are generally, it's just lifted from the latest quarterly or annual report for the company, if it's a publicly traded company. And assets obviously kind of fluctuate, whereas liabilities don't fluctuate. So liabilities can kind of tell you a lot about the company and a lot about how the bankruptcy is going to go. They often, I think you have another slide there for creditors. This is all part of the same, these slides are all part of the same first document that'll be filed called the petition. And this list of creditors, keep in mind, these are only unsecured creditors. So these won't be the lenders. These won't be people who have liens on the company's assets. Generally, it'll be bondholders, and that's what the Bank of New York Mellon is. That's a bond issue by Claire's. And then everything below that kind of looks like trade creditors, like pop sockets and stuff like that. And so these are the unsecured creditors. These are the people who are going to take the bulk of the hit from the bankruptcy. Unsecured creditors are the lowest priority creditors, so they get paid last in a bankruptcy. And so the petition, when it's filed, will tell you the key things. It tells you when it's filed. It'll tell you the size of the liabilities. They often say on there if they expect unsecured creditors to be paid. Sometimes they don't, which is a bad sign for the obviously for people like trade creditors. And then it gives you the list of the 30 largest unsecured claims. And something I always look for is, you can quickly kind of get a sense a little bit if you're not unfamiliar with the company, like why it ended up in bankruptcy. Sometimes they'll list litigation creditors. You see that a lot with like Purdue Pharma, which the maker of OxyContin, when they filed for bankruptcy, litigation creditors were the main reason they were in bankruptcy. And that kind of gives you a sense, why the company's there. In the case of Purdue, because they were being sued by, every town and county across the country. And then other documents you're going to see on the first day. So they call these first day documents, and they call the first hearing the first day hearing. It doesn't always happen on the first day. It's just kind of a term of art that's used in the business. And the other,
we go down to the first day slide.
Declaration.
Yep.
Is that what you're going to say? Yeah. So there's a document called the first day declaration. Sometimes it's an affidavit, doesn't really matter. The key thing is it becomes the evidence that the company is going to use when it goes to court on the first day hearing to ask the judge to do a whole bunch of things. Because the company's in bankruptcy, it needs permission to do anything. It needs permission to pay wages. It needs permission to keep the utilities, the lights on. It needs permission to pay insurance policies, all sorts of stuff. And that's what this document does. It provides like the witness testimony so the judge can comfortably approve all those things. But what it does for the reporter, it also tells like how the company got into bankruptcy, why it's distressed, what's gone wrong. And again, if you're unfamiliar with the company, it gives great background. It also is telling this from the company's perspective, since this is often a, like I'm thinking like Purdue, for example, they made it sound like it was going to be, like it was this quick plan to resolve everything and everybody's going to be happy with it. And 2 years later, it took, it was 2 years before Purdue got out of bankruptcy. So what I'm trying to say is they paint very positive pictures in these first day declarations, as you'd expect. But it kind of gives you a sense of what the company's trying to achieve in their bankruptcy filing, why they're in bankruptcy, what they're trying to achieve, what they hope to look like when they come out.
Right. This is usually, for a lot of bankruptcy reporters, the second document we're trying to find in the system after the petition itself. Sometimes it takes a day to show up, but these are really good to look for. There's sworn testimony usually by someone like a chief financial officer or someone who was appointed to help the company through bankruptcy. Maria, can you maybe just talk a little bit about how you use this kind of document to craft a quick story with a bunch of background about the company and what happened?
Sure. So as Tom was saying, the first day declaration is just full of useful information for a story, especially on the first day of a bankruptcy. It can give you important information about the types of debt and how much debt it has. Like we looked earlier at the petition, which tells you a very general range of debt, like an overall amount that a company has, but the first day declaration will usually go into pretty extensive detail about the type of debt and what it's secured by and how much there is. So that's really good information to find. That's usually listed under the capital structure. That's usually the name of that section. And then there's a section that's literally called events leading up to the Chapter 11 filing or something along those lines. And that's exactly what it sounds like. It may go back years. It may go over certain acquisitions it made that went south, or certain litigation that it's facing that has caused it to file for bankruptcy. That's really the most useful information you can find in there. It'll also give you information about who else is involved in the case, who the most important creditor group is, who the lawyers are, things like that. So this document especially is just chock full of good information. And yeah, I think that's pretty much it for that document, right?
Yeah, I'd say too, it often, because like a big question you'll have in any story about a bankruptcy is why, like, why is this happening? Why did the company file? And even if it's maybe not the full picture, the company will typically give some, explanation for why it's in the situation it's in today. And, through your reporting, you can suss out whether that's really accurate or not. But, pretty much every bankruptcy story includes what went wrong. And I think in a first day declaration, you will usually get some hinting at an explanation for that.
I will add that just a warning, press releases around bankruptcy often like to play really fun tricks. They like to avoid using the word bankruptcy. They provide very little information about what happened, but this is why it's often good to head straight to the court documents because, under sworn oath, more details come out.
That's a really good point. A lot of times in press releases, they won't give you any idea of what they're planning on doing. And you really got to dig through, especially this first day declaration, to get a sense of what exactly is going on.
I think that's a great overview of where to start. So the next place I wanted to take this is talking a little bit about, what happens next to a company and kind of further coverage. I wanted to go back to the first slide, which is an example of the Claire's capital structure. And maybe we can start with Alex explaining a little bit about what you have here, what you can learn from looking at a company's capital structure and what that tells you about how they're going to pay their debts.
Yeah, sure. So looking at Claire's right now, we see there's like a very colorful capital structure in front of us. So we can see towards the top, there's a pre-petition APL, pre-petition meaning pre-bankruptcy petition, a pre-petition revolving credit facility. Revolving credit facilities are very common for large corporations to hold. The best way to think of it is like a credit card for companies that they have with banks typically, where they can have zero balance or they can max it out if they want to. And it's not uncommon to see a maxed out revolving credit facility before a filing, typically because the company's exhausted all means to pay their debts or pay their creditors before needing bankruptcy protection. Below that, you'll see the first lien term loan. That's also very common instrument large companies take out. It's first lien, meaning that in theory, the lenders have a first lien on the assets of the company that would in theory secure their assets in case something were to go wrong, aka you wind up in a bankruptcy process. So it kind of first lien implies they're having a first claim on value left in the company before other creditors might. And as you can see, there are also below the first lien term loan, 9% and looks like 6 1/8 notes. In this case, these are bonds versus term loans. They're both forms of borrowing money. They just tend to come from different vehicles. Typically, bonds need to be registered with the SEC. Term loans are not. considered securities under the eyes of the SEC. So there are different disclosure requirements around them. That's a little technical for this, but more or less understand these are like two types of secured credit facilities that a company might have. Below, you start to see now you're going down the credit spectrum. So now you have second lien notes. Obviously, there's a first lien. These guys would have the second lien on whatever value remains. Then there's unsecured, and unsecured means there's actually no security of assets behind the borrowing that the company took. It's more or less the, like full faith of the company to repay. That is the pledge that the borrowers there have. So these different credit facilities all have different providers typically that lent into the company. I mean, a revolving credit facility, like I said, it's typically from big banks. I think JP Morgan, Bank of America, Goldman Sachs. Term loans and high yield bonds tend to be owned by asset managers. So you can think of like a really big mutual fund. There are CLOs, which are big loan portfolio managers that lend to companies that might hold these. So sorry if I missed part of your question, Claire. I was just kind of going through.
No, I think that's helpful. I think I just as a follow-up, these are in bankruptcy, what happens is called a payment waterfall. And so in many cases, every single cent needs to be paid back to the first part of the stack before the second part gets anything, and down and down and down it goes. And so the reason that this is something we just wanted to show you and get you thinking about is this is a clue of who is going to be fighting for the scraps in this any sort of filing scenario.
Yeah.
We have some questions coming in. One thing that maybe we can go over briefly, we have a question that says, can you speak to DIP lending? That is debtor in possession financing. And Alex, I'll let you briefly talk about what that means and how to kind of cover that.
So yeah, DIP loans are loans that a company will arrange before it enters bankruptcy and will help it fund the costs of going through bankruptcy. I think as Maria alluded to earlier, while bankruptcy offers a lot of protections, you can put a stay on litigation and try to keep your creditors from coming after you and turning off the lights. You also have restrictions on how much cash you're able to use as a company, and you're not allowed to have money still going out the door while in theory you're trying to restructure your finances and your balance sheet. So DIP lenders will provide typically a specified amount of money to help the company get through bankruptcy. DIP lenders, though, can be a lot more than that. DIP lenders often will have an interest in buying the company out of bankruptcy or becoming a large stakeholder in it. You'll see examples where DIP loans can be converted into equity in the company once the bankruptcy is over. Or DIP lenders can even end up owning the whole company in certain cases. So there are a lot of court provisions around how much the DIP a company is allowed to take, and a judge has to approve a lot of the terms and the budgeting behind a DIP financing. But it's very crucial for a company entering bankruptcy. And if a company doesn't have a DIP lender lined up before filing, that's typically a sign that there is a lot of trouble going on there. So I don't know if you guys have anything to add, but that's sort of some high level thoughts I can come up with off the top of my head.
So Maria and Tom, going into that, we've talked a little bit about very first, first day hearings, what happens then, but bankruptcy can be a process that, while there are companies that have done it in a day, usually we're looking at a process that's going to take a matter of months or even years. So when you're trying to figure out what to cover, how do you pick which hearings to call into? And how do you know sort of you have a story about an ongoing bankruptcy?
Sure. So there are a lot of hearings within a bankruptcy case. The important ones, obviously, are the first day and what they call the second day, which usually happens a month later. That can sometimes be procedural, but it can also, be good to check into because it can sometimes just serve as a status conference, tell you what exactly is going on and if things are going according to plan, or if something has gone wrong, or if there's a new interested buyer or something. It's usually good to listen into those first few hearings if possible. Another important one, the real big one is near the end of the case. It's called the plan confirmation hearing. That can last an hour. It can last several days. It depends on whether the lawyers have shored up support among all the creditor groups ahead of time. If it's going to be a long hearing, that means there's going to be a lot of arguments and testimony. And you kind of have to play it by ear. You probably want to listen to the beginning, but you can probably skip some of the days in between, unless you're interested in one particular witness who's going to testify, like say the CEO is going to testify. You might want to listen into that. During the case, there are other hearings that are interesting and can produce interesting stories. For example, a sale hearing, if they're going to be selling their assets. If the sale is contested, like say there's a creditor that says, I actually have someone else who I think should buy the company, and we just need to throw this all out the window and start all over or something. That can be very interesting. The DIP hearing, we just discussed the DIP loan. That's always usually interesting. What's good to look out for generally in these hearings is what the judge is saying. Even if the judge doesn't rule on something, often if you're listening closely enough, you can tell how they're leaning on a certain matter one way or the other. And since most of these really big bankruptcies tend to happen in one of three courts, you kind of get to know the judges and you get to know like how they react to certain things. So those three courts are Delaware, the Southern District of New York, and the Southern District of Texas. And the nice thing about all of those courts is that all the judges let you call and listen into their hearings live. It's great and it's free. So that's a huge help when you're covering a case. And I think the Texas court even posts audio of the hearings afterwards on the docket. So if you miss it, you can go back and listen to it. It's also good to listen for what the lawyers are saying, of course, during the hearings. If there's a hint of things not going according to plan, that's a good way to find out. Boy Scouts is a really good example of that. That case has been going on for almost 2 years now, and it's a mess. It's just really, it seems like every other month something goes wrong, something goes not according to plan. So it's really good to listen into those hearings, even if it doesn't seem like there's going to be anything super important happening. If you are able to listen into a hearing for a case you're covering, I recommend it, just in case you find out something that's not in the papers. On the other hand, they're very boring hearings that you don't want to cover. They may have a hearing just to approve lawyers to represent certain parties. You don't really care about that. But usually in these big cases, the lawyers will file an agenda a day or two before the hearing, and you can look through it and see what exactly is going to be happening at the hearing and decide whether or not you think it's worth covering.
Yeah, and so just to reiterate, that is all stuff that you can find on the claims agent's website. If you're trying to figure out where to start, just Google name of company bankruptcy claims and agent. Prime Clerk is a big one. Stretto is another big provider. It's all free. So I'm just going through some questions that have come in, and one of them is, are any of us lawyers or did we go to law school? I think the answer for that is no, but I guess I would expand that to Tom. Maybe you can talk a little bit about sort of how you got comfortable covering courts and the legal beat, and just sort of tips for beginners who didn't go to law school.
I kind of lucked out in a way that I started during the financial crisis, and there was just so much going on that, and it was all so confusing that I kind of got away with not being terribly specialized, and I just kind of learned by doing it. I really didn't. It's embarrassing how little I knew about the court system. when I started. I had actually moved here from I was overseas for about 10 years and came back to the United States. And so, I mean, I was just really unfamiliar with the whole system. And I got familiar honestly by reading a lot of court filings, attending a lot of hearings. When I first started, I think I said I was mainly focused on covering the court in Delaware, which at the time was really a pretty active court. It was probably the main court at that time. And just attending a lot of hearings and asking a lot of questions of people there. One downside of monitoring remotely is you can't really turn to a lawyer sitting next to you, ask them, what just happened, and say, hey, can you grab a coffee afterwards and kind of walk me through all this. That's how I really kind of found my footing when I first started. A lot of it was just, reaching out to people and finding a friend who can kind of walk you through stuff.
Thanks, Tom. And one follow-up to that, just about finding good stories, maybe if you can't go to court. There's some other documents other than the ones that we showed you that can be really interesting for local reporting, particularly looking at bankruptcy fees, executive bankruptcy bonuses, which are a thing. Tom, can you talk about some key documents you might also look for? And Maria, if you have other ideas, feel free to chime in.
I think Maria wanted to talk about the executive bonuses. I'll just mention that a couple things to watch for in a case. There's something we didn't mention yet, and that's the creditors committee. Every case, or just about every case, will have a creditors committee appointed. And sometimes you can kind of glean interesting things from that. If you have, Claire's would be a good example. If you have a committee appointed and it's made up largely of, say, trade creditors, it's going to have a certain feel to it than it won't have if it's a 3-member committee who are all representatives of bondholders. They're just going to have different interests than, the trade creditors will probably want to see the company survive because they can keep selling the company goods, whereas bondholders may have bought their bonds on 2 cents on the dollar and don't really care if the company gets liquidated at 4 cents on the dollar on those bonds because they're going to make a killing. So just the creditors committee makeup can make a big difference. And when the creditors committee is made up, they also will go through a process of hiring a lawyer, and they get a budget for that law firm, and they get a budget to do their own investigations. They're allowed to, they get a budget from the company to also hire bankers to review, the plan, and to sometimes they'll go out and even try to find buyers and things like that. In Delaware, another way I really got my feet wet was they have a physical meeting of the creditors. They come to a hotel lobby, hotel ballroom in Delaware. And this was a great way to meet people. So they would bring in, or they wouldn't bring them in, all the lawyers and all the bankers would come in to pitch that committee once the committee was formed. Really, most of the day was spent with them sitting around the lobby drinking coffee, and it's a great time for a reporter just to walk around the room, meeting people and handing out cards. And that was the other way I really kind of learned the beat. Was at those creditor committee, they call them formation meetings. I don't know how they do it during the pandemic. But that's kind of a lost part of the business, I think, during the pandemic. But that was another interesting way to meet people, and you can learn a lot about how the case will sort of take shape by who is on that committee. And I just mentioned briefly, really quickly, if you look at the Purdue bankruptcy, the co-chair of the committee is a guy named Ryan Hampton. He's a recovering addict from pain medications. And he's been doing a lot of media tours. I think he just published a book about the experience, saying how he felt the whole experience was so co-opted by certain members of the creditors committee. It's kind of a funny thing to write a book about, but I believe that's what he wrote his book about. And he does all these media interviews and kind of get a sense of how much that creditors committee can shape the overall bankruptcy.
Maria, do you want to talk briefly about executive bonuses and stories that can come from that?
Sure. I'm sure a lot of you saw stories, I think last year, about executives at companies receiving bonuses right before their companies file for bankruptcy. Hertz is a really good example of that. So that's been happening more often recently, in large part because if you give an executive a retention bonus before a bankruptcy, that means there's less, there's no transparency into it. In bankruptcy court, if you're handing out bonuses or if you're seeking approval to pay bonuses, you have to get approval from the bankruptcy judge. And that's a whole process. And you have to file a bunch of papers explaining why somebody, or rather the plan for somebody to earn a bonus. For executives, they're not allowed to receive retention bonuses during a bankruptcy, but they can receive incentive bonuses. So you have to prove to the judge that these payments would be incentivizing. They're not retention based. So that can be really interesting. You'll often see, we haven't even talked about the U.S. trustee yet, I don't think. The U.S. trustee is the branch of the Department of Justice that oversees big corporate bankruptcies. You'll often see the U.S. trustee objecting to these kinds of bonuses and saying, like, this is just inappropriate. You know, unsecured creditors are getting next to nothing, and yet you're paying executives millions of dollars in bonuses. That's unfair. So that's always a really interesting story to cover. And those are generally called key employee incentive plans or key employee retention plans if they're for non-executives. So if you're looking through a docket and you see that, that can be an interesting story. Another interesting story that you can find in documents is how much lawyers are making. That's all public. It's great. They have to file monthly or quarterly fee applications, basically. And it includes all the information about the individual lawyer's rates and how many hours they worked. So that it's always interesting to see how much these hotshot lawyers are making on representing bankrupt companies, or sometimes they're representing the unsecured creditors committee that Tom just talked about. Those fees are also paid by the bankruptcy estate. So in cases like Boy Scouts, like I just mentioned, I think they're around $150 million in fees at this point. That's a lot of money. Puerto Rico has been in bankruptcy for like 4 years now. They're at like $1 billion in legal fees. So all that information is public and readily accessible if you just take the time to scroll through the docket.
Thanks. So I'm going down our question list, and others, if you have anything, feel free to drop in the chat. We have a question here going back a little bit to what we were talking about earlier about creditors committee, and I think I'll kick it to Alex because it relates to our capital structure discussion. But when it comes to a company in bankruptcy, there's unsecured creditors, there's secured lenders, there's DIP lenders and other buyers. Who ultimately ends up really driving the bankruptcy process and calling the shots when it comes to getting a company out of bankruptcy?
Yeah, I mean, this is like, that's the $64,000 question. When you think about what's the point of this whole process? It's to reorganize an estate and to offer recourse or some kind of deal with people you maybe can't pay entirely. So, when you're going through these cases, it's important towards the end of a case to sort of look at the treatment of creditors, and people who aren't being paid back in full are entitled to vote on the plan. So that's the big question, is sort of, and in finance, in this, where that ends is often called the fulcrum. And when you think fulcrum, think leverage, because that's, classical mechanics, where you get the most leverage at is at the fulcrum point. So if you're looking at a really solvent company, solvent's not a good word here. If you're looking at a company that's in relatively good health, maybe they had to file because they weren't able to meet the terms of some debt that they had taken out, but everyone is very optimistic on the business. There are some investors that are willing to kind of maybe put in more cash. You're going to see there with that, the company may be like, look, first lien or secured creditors under the plan we have, you're getting paid in full. So you don't necessarily even have a big role to play in the discussions for how we're going to reorganize the balance sheet here. And in that case, maybe you have the unsecured creditors of the company are the group who are kind of in that fulcrum position where they may be, getting paid back 80% of what they're owed, and 20% of what they're owed is going to be compensated in the form of new stock in the company. However, if you're looking at a case where, this is like a free fall bankruptcy, the business can't even operate anymore. I'm thinking right now of a bankrupt oil refinery that I write about based in the Virgin Islands that, essentially the EPA's revoked its permits. This company doesn't really necessarily have a business anymore. In that case, it's not even clear if the first lien creditors are going to get paid back. So in that situation, they would certainly have more leverage because they're closer to where the fulcrum likely is. And, if you ever get in the weeds enough, there are cases where the fulcrum security moves. In Hertz, it was expected that the unsecured bondholders represented the fulcrum security, but by the end of the case, they were considered a kind of fully compensated creditor class, and the fulcrum in the situation actually moved to the pre-existing stockholders. So the answer is it varies. It's probably one of the most interesting dynamics in the case from a financial perspective. And, it's worth sort of thinking about what the company is saying about who it thinks it can pay back. If it releases a plan, does it say it's going to pay back, certain constituencies of creditors in full? So yeah, it's never clear cut, and it's very dependent on the specific case. Yeah.
Thanks. So one other area I just wanted to touch on is we've spent a lot of time talking about where in documents you can find things, if you're there in person, which lawyers you can buddy up to. But if you're just trying to get your handle around a situation, whether it is in court or out of court, can you guys speak to just some sort of sources, types of sources that might have information on a scenario to help reporters break news?
I can start. I mean, like I said, from maybe if you're looking at this more from a financial angle, try to find out who the company's biggest creditors are. Is it a local bank? Is it an investment bank? Do they have debt holdings at credit funds that maybe you can get in touch with? There are a lot of impacted parties in these cases, and frequently when people lose money, they're not happy and would like to talk about why they're not happy. So that's a great way to sort of, maybe find someone who can tell you more about the situation than maybe the company is saying in public filings.
Yeah, you can try to talk to lawyers involved in the case. I often find that lawyers representing the company itself are more guarded, but if you talk to lawyers representing creditors, they might be a little more open to talking to you about what's going on in a case. Another source, not necessarily to find out about what's going on in a case, but if you're just looking for help understanding a process, there are quite a few bankruptcy law professors who are happy to chat. A lot of them are very active on Twitter. You can find them fairly easily. And they're good to talk to if you're like, I don't understand what this means. So that's another good option. The American Bankruptcy Institute also has a pretty good media team. They're good to talk to if you need some help.
I'll just jump in to say that the American Bankruptcy Institute also keeps a lot of data on just aggregate numbers of bankruptcies, industry trends, and that can be just a good resource for more of the trend story, or if you're looking for some data. So I'd like to kick it over to Tom again. Tom, you are very good at not just looking at bankruptcy, but also digging out just interesting legal situations out of, deep in these court weeds. And so, can you talk a little bit about your process and how you kind of find interesting legal situations? Because that also, can be a big tip off that, a company's entering distress or going to run into issues.
I think there's so much information in a typical bankruptcy case, but it's not always easy to find that information. I think it's two things. You kind of have to know where to find information, but also you really do need somebody, hopefully you can find a friend who can sort of point you to where you might find interesting information. And I think, as Alex said, you have so many people who are not getting paid and are really not very happy with the situation. Maybe their lawyer doesn't want to say anything, and oftentimes a lot of the lawyers are locked down under non-disclosure agreements, but the client the lawyer represents often, I'm sometimes amazed how much they, spout off about things, and then you can kind of, work with people to find things. And some of the things you can find, there's two sets of documents that come in the first 90 days, I think. There's one called the schedules and one called the statement of financial affairs. These are really dense documents. They can run hundreds and hundreds of pages. But I've seen really good stories done, oftentimes by local reporters, on things like payments that were made to lobbying groups that can sort of, show how the company was trying to get, like local tax breaks to stay in business, or people were able to ferret out. I saw a good story one time about someone ferreted out these jets that were owned by a very tiny, I think it was an oil exploration business, something like that. And, Super Bowl box seats that were all disclosed in these documents, because the documents, the company will have to disclose literally every asset it has, down to, you'll see companies even disclosing like, trophies from the local Little League that they display in their, corporate offices and things like that. They have, I guess, accountants go through and, assess everything. And someone did a really good story going through one of these kind of filings, and, found these jets and, football box seats and stuff like that. Again, it's helpful to have somebody kind of point you these things, and not the kind of thing you really stumble upon. They are there. You also find, once a company's in bankruptcy, something to watch for sometimes is when you have, the whole process can seem very, it's all same professionals. It tends to be every case the same lawyers, the same financial advisors. Sometimes you'll get cases where you get individual investors, or you get individuals who own a lot of leases for a retailer, or you get, with some of the energy cases, you got a lot of people own the land on which the wells are and stuff like that. And that can open up a really interesting dynamic too, where you suddenly have these individuals who are not familiar with the process, and judges can be sympathetic to them. And sometimes you'll see, there's good stories there to be done about some of the characters that wind up in these cases, about some of the individuals that get swept up in these cases. And I'd say the one final thing too is always think about the individuals caught up in these things, in that, companies that go bust oftentimes have very interesting stories about how they came about, or interesting stories how they, what got them there. And a lot of times that's a very interesting executive. That executive may not be there anymore. But if they are recently departed from the company, oftentimes they just love to talk and talk about how the new management came in and screwed everything up. So that's another thing to keep in mind, is that, look for, people that recently left the board or recently left the management, like within a year or two before the filing.
Thanks. So I pretty much only have time for one more thing, but I think we'll end on kind of what happens on the other side. We've spent most of our time talking about Chapter 11, which, if it works, the company will emerge, it'll come out of bankruptcy, it will still be alive and kicking, having gotten rid of a lot of debt. Alex, you mentioned you were working on a story about Hertz today, which is an example of that. Kind of what's your advice for reporting on a company who has come out of bankruptcy? What stories are left to tell?
Yeah, I mean, it can be a gift that keeps on giving. Typically, if you have a non-liquidating bankruptcy, a company will emerge with new owners, could emerge with a new capital structure, new debt that are put in place in connection with exiting the case. So keeping track of, what are these new owners or maybe new lenders doing out of bankruptcy is really key. Hertz, for example, secured $1.5 billion from a, let's say, alternative asset manager called Apollo when it exited bankruptcy, as kind of a, this is a pillar of the company's, financial footing as it goes back into a post-bankruptcy world. And as I've been keeping tabs on Hertz's SEC filings and press releases, the company announced today it's going to borrow a lot of money and pay out Apollo from the stock investment it put in place when it exited bankruptcy. So that's a fascinating story about how Apollo kind of came in as a sort of interloper, if you will, provided some cash to the company, and now is about to make a lot of money from it. So if it's a publicly traded company, keep an eye on major filings, obviously, both for court filings and SEC filings. There's a lot of stuff. A lot of it's not going to be useful to you. But, just learn how to filter through, what's going to be relevant and contain new information versus what's a kind of extraneous add-on fact or doesn't really add anything new. So, I would say for bankrupt companies that successfully exit, with new owners or new backers, just keep an eye on what those guys are doing. Are they staying around long term? Do they want to really own this business now, or was this kind of a means to an end for them to maybe make a quick buck and move on to the next thing? So that can be one angle among many, but that's definitely a common one I would look out for.
Great. Well, I think we can leave it there. I really appreciate everyone for joining us today. I see some requests for the PowerPoint, which I will let SABEW make sure that they can email out, but I'm fine with that. And Adrian.
Yeah, thank you, Claire, and we'll be sure to get that PowerPoint to the panel, the attendees today. But again, thank you. This has been a really great primer, and everyone has been very knowledgeable, and Claire did a wonderful job moderating this discussion. To our listeners, please keep an eye out for SABEW's next monthly training session. Details on that will be shared soon, and as always, you could check sabew.org for updates. And finally, if you have a suggestion about a future training topic, please email sabew@sabew.org. We really do appreciate the input, and we appreciate all the attendees for joining us today. And with that, that concludes today's call. Thank you.